The three methods for settlement of industrial disputes are as follows. 1. Conciliation. 2. Arbitration. 3. Adjudication. 1. Conciliation. In simple sense, conciliation means reconciliation of differences between persons. Conciliation refers to the process by which representatives of workers and employers are brought together before a third party with a view to persuading them to arrive at an agreement by mutual discussion between them. The alternative name which is used for conciliation is mediation. The third party may be one individual or a group of people. Characteristics of conciliation. By the conciliator or mediator tries to remove the difference between the parties. She persuades the parties to think over the matter with a problem-solving approach. With a give-and-take approach. She only persuades the disputant to reach a solution and never imposes his/her own viewpoint. The conciliator may change his approach from case to case as he/she finds fit depending on other factors. According to the Industrial Disputes Act 1947, the conciliation machinery in India consists of the following. A. Conciliation Officer. B. Board of Conciliation. C. Court of Inquiry. Description. 8. Conciliation Officer. The Industrial Disputes Act 1947, under its Section 4, provides for the appropriate government to appoint such number of persons as it thinks fit to be conciliation officers. Here, the appropriate government means one in whose jurisdiction the disputes fall. While the commissioner/additional commissioner/deputy commissioner is appointed as conciliation officer for undertakings employing 20 or more persons, at the state level, officers from Central Labor Commission office are appointed as conciliation officers. In the case of central government, the conciliation officer enjoys the powers of a civil court. He is expected to give judgment within 14 days of the commencement of the conciliation proceedings. The judgment given by him is binding on the parties to the dispute. B. Board of Conciliation. In case the conciliation officer fails to resolve the dispute between the disputants, under Section 5 of the Industrial Disputes Act 1947, the appropriate government can appoint a Board of Conciliation. Thus, the Board of Conciliation is not a permanent institution like conciliation officer. It is an ad hoc body consisting of a chairman and 2 or 4 other members nominated in equal numbers by the parties to the dispute. The board enjoys the powers of civil court. The board admits disputes only referred to it by the government. It follows the same conciliation proceedings as is followed by the conciliation officer. The board is expected to give its judgment within 2 months of the date on which the dispute was referred to it. In India, the appointment of the Board of Conciliation is rare for the settlement of disputes. In practice, settling disputes through a conciliation officer is more common and flexible. C. Court of Inquiry. Court of Inquiry means a court under this Act to settlement industrial dispute. 2. Arbitration. Arbitration is a process in which the conflicting parties agree to refer their dispute to a neutral third party known as arbitrator. Arbitration differs from conciliation in the sense that in arbitration the arbitrator gives his judgment on a dispute, while in conciliation, the conciliator disputing parties to reach at a decision. The arbitrator does not enjoy any judicial powers. The arbitrator listens to the viewpoints of the conflicting parties and then gives his decision, which is binding on all the parties. The judgment on the dispute is sent to the government. The government publishes the judgment within 30 days of its submission, and the same becomes enforceable after 30 days of its publication. In India, there are 2 types of arbitration: voluntary and compulsory. Voluntary arbitration. In voluntary arbitration, both the conflicting parties appoint a neutral third party as arbitrator. The arbitrator acts only when the dispute is referred to him/her. With a view to promote voluntary arbitration, the Government of India has constituted a tripartite National Arbitration Promotion Board in July 1987, consisting of representatives of employees, trade employers, and the government. However, the voluntary arbitration could not be successful because the judgments given by it are not binding on the disputants. Yes, moral binding is exception to it. Compulsory arbitration. In compulsory arbitration, the government can force the disputing parties to go for compulsory arbitration. In other form, both the disputing parties can request the government to refer their dispute for arbitration. The judgment given by the arbitrator is binding on the parties of dispute. 3. Adjudication. The ultimate legal remedy for the settlement of an unresolved dispute is its reference to adjudication by the government. The government can refer the dispute to adjudication with or without the consent of the disputing parties. When the dispute is referred to adjudication with the consent of the disputing parties, it is called voluntary adjudication. When the government herself refers the dispute to adjudication without consulting the concerned parties, it is known as compulsory adjudication. The Industrial Disputes Act, 1947 provides three-tier machinery for the adjudication of industrial disputes. 1. Labor Court. 2. Industrial Tribunal. 3. National Tribunal. A brief description on these follows. Labor Court. Under Section 7 of the Industrial Disputes Act, 1947, the appropriate government, by notifying in the Official Gazette, may constitute labor court for adjudication of the industrial disputes. The labor court consists of one independent person who is the presiding officer or has been a judge of a high court, or has been a district judge or additional district judge for not less than 3 years, or has been a presiding officer of a labor court for not less than 5 years. The labor court deals with the matters specified in the second schedule of the Industrial Disputes Act, 1947. These relate to 1. The property or legality of an employer to pass an order under the standing orders. 2. The application and interpretation of standing orders. 3. Discharge or dismissal of workers, including reinstatement or grant of relief to workmen wrongfully dismissed. 4. Withdrawal of any statutory concession or privilege. 5. The illegality or otherwise of a strike or lockout. 6. All matters other than those reserved for industrial tribunals. Industrial Tribunal. Under Section 7A of the Act, the appropriate government may constitute one or more industrial tribunals for the adjudication of industrial disputes. Compared to labor court, industrial tribunals have a wider jurisdiction. An industrial tribunal is also constituted for a limited period for a particular dispute on an ad hoc basis. The matters that come within the jurisdiction of an industrial tribunal include the following. 1. Wages, including the period and mode of payment. 2. Compensatory and other allowances. 3. Hours of work and rest periods. 4. Leave with wages and holidays. 5. Bonus, profit sharing, provident fund, and gratuity. 6. Classification by grades. 7. Rules of discipline. 8. Rationalization. 9. Retrenchment of employees and closure of an establishment or undertaking. 10. Any other matter that can be prescribed. National Tribunal. This is the third one-man adjudicatory body appointed by the central government by notification in the Official Gazette for the adjudication of industrial disputes of national importance. The central government may, if it thinks fit, appoint 2 persons as assessors to advise a national tribunal. When a national tribunal has been referred to, no labor court or industrial tribunal shall have any jurisdiction to adjudicate upon such matter.